want to do that first one?
Yes. Just change the mind. Okay, the court is back in session in cause number 332864. Case is styled the state of Texas versus Chastity Shanae Broussard. Ms. Broussard, would you please raise your right hand? Ms. Broussard, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, help you God?
Yes.
Okay, Ms. Broussard, you may put your hand down. Ms. Broussard, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
And are these your initials stating that you want to waive your right to an attorney and represent yourself?
Yes.
I also have before me a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, Ms. Broussard, do you recognize this document? Is the document, well, let me do this here. I'm gonna give you, did you read the document?
I'm in front of not guilty.
Okay, you said, well, you said two different things. You said you wanted to
Not
get it up.
guilty, and I want to represent myself.
Okay, well, you need to,
I really do.
well, you don't need to sign this document then. Okay, well,
Not guilty.
okay.
and I want
okay, let me do this.
first time I'm seeing, paperwork, like, a lot of people, or,
You need to get somebody? The guy who's coming up? Who is Hawkins? That's him? You could give it back to him. Okay, court is back in session and call number 332-864. Case is Stout City, Texas versus Chastity Shanae Broussard. We have Ms. Broussard who's in court, and Ms. Broussard has previously been sworn in. Ms. Broussard, I have before me two documents. Again, the first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes.
Now, in this document, Ms. Broussard, there's a signature on the line that's titled Defendant. Is that your signature?
Yes.
And there are initials on the line that states that you want to waive your right to an attorney and represent yourself. Is that correct?
Yes.
Now, Ms. Broussard, pursuant to Ferretta versus California 422 Southwest, US 806, I need to ask you a couple of questions.
Yes.
First question is, Ms. Broussard, have you ever studied law?
Yes.
You have? Okay. Have you ever represented yourself in a criminal action?
No, sir.
Do you understand the charges against you?
Yes, sir.
And Ms. Broussard, what are you charged with?
Permanent issue.
Okay. Now, are you aware of the maximum penalty for that charge?
No, sir.
Okay. Are you familiar with the exact legal elements for the charge, for what you're charged with?
It's a misdemeanor, right?
Okay, my question was, are you aware,
No, sir.
are you familiar with the exact legal elements of the charge?
Permanent issue.
Do you understand the exact elements, legal elements? You do?
Yes, sir.
Okay. And what are those elements?
Permanent issue.
What are the elements of criminal mischief? Okay, now, do you realize that if you are found guilty, if you're found guilty of this offense, because it is a Class A misdemeanor, the range of punishment can entail that you serve anywhere from 0 to 365 days in the Jefferson County Jail. Are you aware of that?
Yes.
And are you aware that the fine can be anywhere from $0 to $4,000? Now, Ms. Broussard, do you realize that if you represent yourself, you are on your own? And as a judge, I cannot tell you how you should try your case or even advise you as how to try your case. I cannot help you in any way. Do you understand that? Are you familiar with the Texas rules of evidence and Texas case law? Okay. And do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted, and in representing yourself, you must abide by those rules? For example, how do you conduct a voir dire examination? How do you conduct a voir dire examination? Do you know how to conduct a voir dire examination?
Sir, I'm not familiar with, so,
Okay, voir dire means how do you pick a jury? You know how to pick a jury? Okay, what are the grounds for excusing a juror for cause?
sir, I know I'm not guilty of this.
Okay, Ms. Broussard, I must ask you these questions. Okay, so do you know what the grounds are for excusing a juror for cause?
No, sir.
Okay, what is hearsay? Do you know what hearsay is?
Yes,
And what are some of the exceptions to hearsay?
Some exception.
Yeah. What are some of the exceptions to the rule of hearsay? Okay. I take it by your silence, you do not know any of the rules to the, what is hearsay or what are the exceptions to hearsay. Now, do you know what is proper impeachment of a witness? You could say impeachment or discrediting a witness.
I just know I'm gonna give it a short.
That's not my question. My question, I must go through a line of questions to determine whether or not,
I can represent myself.
yes,
Okay.
okay?
Okay.
So, let's see. Do you know when character evidence is allowed?
Yes,
You do?
character evidence.
Yeah, when it is allowed in a trial.
We're not doing a trial, right?
Hmm?
We're not doing a trial, right?
If you plead not guilty, you have a right to have a trial by jury or trial by judge.
I don't want a trial, but I know I'm not guilty. It's short.
Well, it doesn't work like that. Okay, I think I explained to you during arraignment that you have a right to have a trial by jury, and you have a right to waive or give up your right to have a trial by jury. And if you waive or give up your right to have a trial by jury, your case will come before the court in one of three ways. One way is by way of a bench trial, that is a trial by judge only. The other way is by way of a plea bargain agreement, whereby you and the state reaches an agreement to settle your case. And the other way is by way of an unagreed plea bargain agreement, which means that you and the state have not reached an agreement to settle your case, and you want the judge to decide the punishment of the punishment in your case. Okay, so those so at this point, you stated that you would like to enter a plea. Well, you would like to represent yourself, waive your right to an attorney, and to represent yourself, and you are not entering a plea of guilty or no contest. So at this point, you're telling the court is when you say that, that indicates to the court that you would like to have a trial, and your trial will either be by judge or by jury.
Sir, I wanna,
Let me do this here. The court, okay, you're not familiar with the rules, the Texas Rules of Criminal Procedure and the Texas Rules of Criminal Evidence, okay? And so, what I'm telling you is I'm going by what the rules are in the state of Texas, okay? If you said that, one, you're not guilty, and you're not entering a plea bargain agreement with the state, and if you, I'm saying the categories, I mean, you just want it to go away. It doesn't work like that.
No. I'm entering that I'm not guilty.
That's true. And so once you enter a plea of not guilty, we go to the trial mode. It goes to trial, either bench trial, which is trial by judge only, or jury trial. That's what we are. Okay. Once you say you don't come before the court and say I'm not guilty, and the judge say, okay, boom, the case is over. It doesn't work like that in the court of law. Okay, so that's why when you said that you want to represent yourself, and you said that you're not guilty, we go to the jury, and I need to go through what is called a Faretta admonishment or Faretta instruction to see whether or not you're able to represent yourself in a trial. So that's what we are. That's why I was asking the questions that I was asking, that I am asking, and I hadn't finished asking those questions. Okay.
I wasn't trying to disrespect, I'm just saying I'm not guilty.
I understand that.
And by saying not guilty, it automatically goes to.
You have a
trial.
right to have a trial by judge, or you have a right to have a trial by jury. That's the law.
Trial by jury.
Okay, but let me finish asking questions, see whether or not you're fit. I say, okay, do you know when and how to make proper objections? You do? I'm just trying to
If
see your level of knowledge
If
to
it'll-
handle the case.
if it'll- I'm not trying to give you a hard time, sir.
And I'm not trying to give you a hard time either.
I just know I'm not guilty, sure. And I'm go to trial and if I need to let somebody represent me, I will. And just plead not guilty.
Okay, so now that brings us back to the first
I just
application.
wanna get it over
Now-
with today.
Well, it's not gonna be getting over with today by way of a trial.
I
Okay,
don't want a trial.
okay, but, okay. So at this point, when you said you're not guilty, it goes to, we in trial mode, and that trial won't be today.
Okay.
Because, witnesses and the state, everyone has to be given notice.
Okay.
Okay. Now, back to my questions. Do you know when and how to move for a directed verdict?
No.
Okay. Do you know when to proffer, which means to offer evidence to protect the record for appeal?
No.
Okay. Do you know the proper grounds for mistrial?
No.
Okay. Are you aware that failure to timely move for mistrial may waive crucial mistakes made by the state or this court? Do you understand that?
Yes.
Okay. Now, do you know how to request and object to jury instructions? Okay. And again, are you familiar with the Texas Rules of Criminal Procedure?
Yes. Somewhat.
You said somewhat? Okay. Do you realize that those rules govern the way in which a criminal action is tried in a court?
Mr. Holmes. I want to plead not guilty.
I
Because I
understand.
didn't do these charges.
Okay.
And, maybe I should just get a court-appointed attorney and plead not guilty.
So you want to change back to, let's see.
I'm sorry.
All right. Did you give her this here document?
So you want to remark it about
I guess she's gonna have to remark on the last thing she want to apply for court-appointed attorney, which is on line 3.
Can we just get a branch paper?
Yeah, you can just have a seat at that table and you fill it out and read it.
That one, right?
Yeah, no. Yes,
Yeah.
yes, is that one.
Just saying, I want a court-appointed attorney, right?
You just gonna, you requested one at first and then you change it to saying you want to represent yourself. Now you're just gonna change it back to what
Right.
you had the first time.
Right. Just want to keep that same number on the top?
Yeah, the cause numbers, yeah, it doesn't change.
Well, yeah, that's yeah. Where-
Okay. Okay, now let's go back to this document. Okay, now Ms. Broussard, have before me a document that's titled Judge's Explanation without attorney. Ms. Broussard, do you recognize this document? And are these your initials on the line stating that you would like to, I think that's the wrong line. I can see that from the back. It should be, she initial line 4, it should be 3. Line 4 said that she's already been appointed a court-appointed attorney. Yeah.
I'm sorry, I need glasses.
Okay. Okay. So she's ready. Okay, so now Ms. Broussard, I have a document before me that's titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes.
And is this your signature on the line? It's titled Defendant. Now you scratched through the initials on line 4. However, your initials on line 3 states that you would like to request a court-appointed counsel, a court-appointed attorney. Is that correct?
Yes, sir.
I also have before me Ms. Broussard a document that is titled Jefferson County Affidavit of Indigence. And do you recognize this document?
Yes, sir.
On page 2 of the same document, Ms. Broussard, there's a signature that is titled, that is above a line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Now, Ms. Broussard, before you signed and initialed these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay. Now, Ms. Broussard, based on your answers in these documents, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Langston Adams. Attorney Adams will be given information on how to contact you. You will also be given information on how to contact him. Our court coordinator will give you that information. Now, once you get that information, you'll be free to go on your blessed day. Now, Ms. Broussard, the court had to go through what is called a Ferretta versus California instructions to determine whether or not you should represent yourself. And in this court, we do not railroad folks. We just, we want to make sure that you understand your rights and you understand everything that if you want to represent yourself, you have to understand what will be expected of you during a trial.
I didn't want to do, I did not want to do that. I just wanted to get it over with today.
Yeah, but apparently because of the rules, it doesn't work like that. I understand what you want, but we have to abide by the rules. All right, so you're gonna stand on that 4X. Once you get your case reset, you'll be free to go and you have a blessed day. And this will conclude the calling of the courts. Arraignment docket in County Court at Law Number 2, Jefferson County, Texas. Judge Terrence L. Holmes presides.